Hello and welcome. My name is Mark Benton. I'm a English qualified solicitor and I work as a foreign lawyer for Hansan Law Offices, which is a law firm based in Seoul, and we assist many foreign clients with their legal issues in Korea. And today I want to say a few words about employment law strategy. Okay. So the Korean labour law, employment law, is governed by the Labour Standards Act. That's the primary piece of legislation which affects all or most of employer-employee relationships in Korea. And I want to say two things. In general terms, Korean labour law is very pro employee. So I'll tell you a story about this. So I was with cycling with one of my friends, and he works for one of the big multinational companies here, and he hired a staff member ostensibly because they could speak Japanese, and they needed somebody on the team who could speak Japanese. And he was saying it was really highly problematic because things just aren't working out with him. So a rather unfortunate example, this chap had to prepare a PPT, and it was to do with planning and the client during the year, and each month he'd put 5 weeks, and the chap was presenting it in front of the team, and they were looking at it with somewhat with some bemusement because each month had 5 weeks, and my friend said to him, well look, we've got 12 months in a year and you've put each month as 5 weeks. That means the year has 60 weeks. And he said, are you sure that the year has 60 weeks? And the chap he had no explanation, and it's causing problems with the team, it's causing problems with my friend. And the issue is that Korean labour law is very restrictive. He's on permanent employment, and there's just no way to get rid of him, or there's no easy way to get rid of him. So that's one facet to it. Another facet is if you are new to Korea, it's an alien place. You're dealing with what's on your plate at the moment. It's better to be in a position to be able to plan ahead, and this is kind of what this short video is about. Just think some things to be aware of to be able to plan ahead. Okay, so some considerations. The applicability of the Labour Standards Act. So the Labour Standards Act basically applies in full if you have 5 or more employees. If you have 4 employees or less, then it applies in a limited way. So that's something to be aware of. We can advise on the applicability of it where you have 4 employees or less. Should you need our assistance. The other thing to be aware of is the probation period. So you can put an employee on a permanent contract, and you can prescribe for a probationary period just to see if it will work out. And the rule of thumb is basically 3 months. So you can dismiss without notice up to 3 months, but you need to be careful about it. You need to prescribe for it in the contract. The next thing I'd like to talk about is unfair dismissal and fixed term contracts. So, we talked about that. Probationary period and fixed term contracts. Okay, so fixed term contracts. The general rule is that a fixed term labour contract should not be for more than 1 year. It may be renewed, but after 2 years the employee will acquire permanent employment. So basically, if you want to mitigate your risks for a staff member that doesn't work out, somebody who can't count the number of weeks in the year, then there are 2 things that you can do. First one, you prescribe for a probationary period. The second is you put them on a fixed term contract and you roll that over for a maximum of 2 years, and you have to be really careful about when you get to the 2 year period and or the end of the 2 year period, and making sure the employee has no expectations of a further renewal, and therefore acquiring permanent employment. Okay, so let's move on. Something else to be aware of, when you get to 10 employees or more, then you've got to have by law what's known as rules of employment. Rules of employment is like an employee manual which prescribes various things like wages, holidays, procedures, health and safety, etc., etc. This is really quite an extensive document, and you are required to have it when you get to 10 or more employees. Okay, and some other matters that you need to be aware of. So every employer needs to have what's called severance pay, and there are various forms of this. The most basic form is that once an employee has worked a year or more, then they're entitled to 1 month's pay, and that's prorated for periods of more than 1 year. So you need to be aware of that and plan for that financially. Secondly, there's a trend in Korea for employees not to take their holidays and then to expect payment in lieu. So you need to be prepared for that, and you can deal with that to a certain extent contractually. And then finally, something to be aware of, employees telling the truth on their application forms, and then discussions, employees tending to embellish their previous achievements. So it's important to have in your contract a representation or a warranty that all information provided on the curriculum vitae and other discussions is true, complete and accurate in all respects. That can help to a certain extent. Okay, so I hope these are some features which would enable you to give some forward thinking to your employment decisions and career. If you'd like to contact me, my contact details are here. Thank you very much for listening.